Medical negligence, sometimes known as NHS negligence, is when the standard of care provided to a patient under an NHS service falls below a reasonable standard of care. This is sometimes known as clinical negligence, and it can relate to care provided by any medical professional, so a nurse, a GP, a doctor, a surgeon, a therapist, if the standard of care was found to be poor or substandard, and this resulted in avoidable harm to the patient, then you may have a claim for compensation. A duty of care under the English and Welsh legal system is the standard of care that a patient can expect to receive when having any medical treatment. So how we determine if the duty of care is being breached is we look at the standard of care that was provided. So for example, if the patient went to see their GP and they felt there was either a delay in them making a referral for an investigation or for some tests, then we would look at what a reasonable GP faced with the exact same circumstances would have done in that scenario. If it's found that the GP should have made an earlier referral or should have referred for some tests that didn't actually happen, then we can put an argument forward that the duty of care was breached. Obviously, in medical negligence claims, there's a very wide range of different sorts of claims that can be brought. Some areas of specialism, due to the nature of the patients that are being dealt with and the high volume of patients, will involve more claims for medical negligence than other areas. NHS Resolution, who's the public body who oversee the investigation of all medical negligence claims in the NHS, they produce an annual report. And this shows statistically that the areas that lead to the most claims for clinical negligence are accident and emergency medicine, closely followed by orthopaedic medicine, and then finally obstetric and maternity care. Although obstetric and maternity care don't tend to have the highest volume of clinical negligence claims, what they do have is the claims generating the highest total aggregate amount of compensation that's been awarded. For a medical negligence claim to be successful, you have to establish two separate tests. The first is that there was a breach of duty in relation to the standard of care that was provided to you. And secondly, you have to establish that the breach of duty caused or contributed towards you suffering harm or injury. The claim will only be successful if both elements are proven, and the burden is on the person bringing the claim, so the patient or the person who's received the medical treatment, to prove that standard. If a claim for clinical negligence compensation is successful, you will be awarded a sum of compensation. This is split into two separate areas. The first area is for general damages, and that's a sum of compensation to compensate for the actual injury and suffering that you've been through as a result of the negligence. The second area is to compensate for any losses or other damages that you've incurred, so that will be for past losses, and also to compensate you for future losses, so that will cover things such as care and assistance, any private medical treatment or therapy that you may need in the future, any adaptations to the house or car, or other aids or equipment that you may need. Generally, you have 3 years in which to bring a claim for clinical negligence, and that's calculated either from the date that the negligence occurred, or alternatively, if you weren't aware at the point when the negligence occurred and you have a later date of knowledge, then the 3 years will start from that date of knowledge. It's a different set of rules for children. For a child, the 3-year time limit starts from their 18th birthday, so effectively runs until their 21st birthday. And then if the patient is a protected party, so they're deemed not to have capacity under the definition in the Mental Capacity Act, then there's no time limits applied. They can bring a claim at any point, even if it's many years after the actual negligence occurred. The definition of bringing a claim is when a formal claim form is filed at the court. Once that's been done, then the 3-year time frame effectively stops at that point. So to bring a claim for clinical negligence, there are various steps that need to be gone through. The first one will be to speak to a solicitor so that their instructions can be taken, and we can put some funding in place to cover the costs and disbursements in relation to bringing the claim. The next key step is to get disclosure of all of the medical records. This will be both for the provider you think was potentially negligent, but also GP and any other hospital or clinic that you attended. There'll then need to be witness statements taken in relation to what happened, both from the patient themselves and also potentially some family members. And then the key step in medical negligence claims is then to get some expert evidence. What we look to do is go to an independent expert who's got the experience to comment on the specific area of negligence that we're alleging and can say what a reasonable standard of care would have been for treatment in that particular area, and what the causation or consequences may be if it's found that there has been any breaches. Once we've got the medical evidence together, what we'll then look to do, if it's supported that there has been a claim, is that we'll draft a letter of claim. This sets out the allegations of negligence. It's then presented to the NHS Trust or the GP, whoever it may be, and also a copy is sent to NHS Resolution in appropriate circumstances.